Good morning. The Subcommittee on the Interior will come to order. Without objection, the chair is authorized to declare a recess at any time. Today, the Subcommittee on the Interior will examine the impact of Executive Order 13658 on public land guides and outfitters. The executive order mandates a $10.10 minimum hourly wage be paid by employers who contract with the federal government. The order was issued in February 2014, and the implementing rule was finalized by the Department of Labor in October 2014. I want to make it clear that we're not here today to debate the idea of raising the minimum wage in and of itself. That will be done by another committee at another time. But today, we're here to discuss the impact of how this order and its implementation will negatively impact seasonal rural businesses. The order will leave many locales in danger of losing small businesses that are providing outdoor and recreational services to the public. It's particularly damaging to rural economies that rely on tourism revenue. Wyoming had more than 10 million visitors who contributed more than $3 billion to the economy in 2014, according to the Wyoming Office of Tourism. From skiing to river rafting trips, to trips on horseback. Many of these visitors rely on private businesses that operate on federal lands. The federal government has promoted tourism as a replacement for logging and mineral development projects that have been strangled by regulation. So it's rather ironic that now the executive branch is working to regulate wilderness tourism out of business. These businesses provide young Americans an opportunity to obtain employment while also providing a valuable service to the visitors of these taxpayer-owned lands. The rule unnecessarily burdens seasonal operators and small businesses using permits to enhance the use of our outdoors. The Forest Service submitted comments upon the proposed rule, stating that these seasonal guides and outfitters operating under permit are not federal contractors, and as a result should be exempt. As a federal agency very familiar with guides and outfitters using the land under its jurisdiction, the Forest Service recognizes the unique nature of these businesses. It's unfortunate that the Department of Labor chose to disregard them. As Americans, we're fortunate to live in a nation with diverse and beautiful landscapes. These landscapes provide families and individuals affordable quality recreation opportunities. Public land guides and outfitters deliver a service that allows for an in-depth enjoyment of these activities. This executive order unnecessarily endangers the economic existence of this industry and diminishes the enjoyment of our public lands by Americans nationwide. Representative Chris Stewart of Utah has introduced H.R. 2215, the Outdoor Recreation Enhancement Act. This legislation seeks to maintain the current level of tourism on public lands. Today we will hear from Congressman Stewart about his legislation to address these concerns and protect rural jobs. We will then hear from representatives of the outfitter and guide community to discuss how their businesses operate and the effects this rule will have on them. We will also hear from a representative of the Department of Labor, Wage, and Hour Division regarding the implementation of the President's executive order and the rule to enforce its provisions across the federal government. What we have here is something that, unfortunately, we see time and again, especially in the West, the federal government in Washington forcing a one-size-fits-all directive on the American people. I sincerely hope that the Department of Labor listens closely to the representatives that we have here and recognizes that this situation as presently drawn up is not workable. I sincerely hope that we can take a common sense approach to this issue and do the right thing. With that, I'd like to thank our witnesses in advance for their testimony. I now recognize Ms. Lawrence, the ranking member of the Subcommittee on the Interior, for her opening statement.
Thank you, Madam Chair, for holding this hearing. Today, we're focusing on the outfitter and outdoor guide business that hold permits to conduct business on federal land. I understand from the testimony that these organizations are looking for an exemption to the federal minimum wage rule so that workers will be paid less than the 1010 required in the President's executive order. I'm always support the rights of businesses to earn a profit in their chosen field. However, I do not support their right to earn extra profits at the expense of hardworking Americans. Just as business owners must provide for their families, so must the people who work for them. We must strike a balance between competing interests. I hope that today's testimony can help us to do so with respect to the outdoors industry. I want to also note that decades of research have shown that raising the minimum wage raises economic growth. And raising the minimum wage is one of the most effective economic tools we have to ensure that the American working class retains its position as the most affluent in the world, a destination is recently lost. President Obama's executive order 13658 established a minimum wage of $10.10 for businesses that contract with the federal government. The order was based on a well-supported finding that raising the pay of low-wage workers increases the quality of their work, more importantly, enables them to support themselves and their families. It should be noted that 29 states and the District of Columbia, as well as 21 cities and counties, have set their minimum wages above the 7.25. It is also important to note that data have shown that an individual that makes the current 7.25 minimum wage earns about $15,000 a year. Now let's assume that a husband and a wife with 2 children both make the minimum wage and work full time. That's a gross income of approximately $30,000. You break that down to monthly and weekly, having to feed, clothe, provide housing. I'm from Michigan. There's no public transportation, so cars, insurance, and gasoline. We are creating a society that I feel has effectively been addressed through the President's executive order. And I do believe firmly that I have the responsibility in this Congress to ensure that in America, that those who are working every day have what they call an opportunity and resources. If they work every day hard and they do their jobs, that they can at minimum support their families and not be in poverty. Thank you so much, and I look forward to the testimony today. Thank you, Madam Chair.
I thank the ranking member. We're pleased that our fellow colleague from the full committee, Mr. Meadows, has joined us today. Without objection, Mr. Meadows is welcome to participate fully in today's hearing. Welcome. Thank you. I'll hold the record open for 5 legislative days for any member who would like to submit a written statement. We'll now recognize our distinguished witness on our first panel. I'm pleased to welcome our colleague, the Honorable Chris Stewart, Congressman from Utah's 2nd District. Welcome, Congressman. We thank you for your appearance today, and we look forward to your testimony. We know you're in a markup in another committee, so without further ado, know that your entire written statement will be made part of the record, and the floor is yours.
Thank you, Madam Chair. It's interesting to be on the other side of the table here. It's kind of lonely down here. Thank you for holding this hearing, Ranking Member Ms. Lawrence as well, to give us this opportunity to look at how the President's executive order on minimum wage is harming seasonal recreation jobs in public lands, and how I believe my bill, the Outdoor Recreation Enhancement Act, can address the problem. This may not be the most exciting issue, I recognize that, but it's an important one. It impacts real people, and I appreciate the chance to be part of the discussion here today. And again, I apologize in advance for the fact that I have to leave immediately after my testimony. Chairwoman, you and I both represent districts that are almost entirely controlled by the federal government. Federal ownership on our public lands has all kinds of frustrating outcomes for the residents of western states, and I'm here to talk about one of those situations where decisions made here in Washington, D.C. are hurting local businesses, local jobs, and access to public lands. In February of 2014, President Obama issued an executive order establishing a new minimum wage for federal contractors, which raises the minimum wage to $10.10 per hour for businesses operating under federal contracts. First, I should note the minimum wage itself is a misguided economic policy that hurts the very people that we most want to help, those at the bottom of the economic scale. Study after study shows that increasing the minimum wage increases unemployment among low-skilled workers. It accelerates the move from labor to capital and makes it harder, not easier, but harder for young people to get those entry-level jobs that develop the basic skills that helps workers advance and earn more. But of course, we're not here to talk about that. We want to talk about the impact the President's actions are having on a specific industry. Because the executive order applies to businesses with federal contract, that includes guides and outfitters and other recreational businesses whose only connection to the federal government is a permit to operate on federal lands. That permit is a pretty tenuous link, but it's enough to bring these businesses under the President's executive order. The Department of Labor's subsequent interpretation of the order requires a number of new regulations that will add additional compliance costs to an industry that operates on very small margins. This increase will force many outfitting businesses to either close or to cease operations on public lands or to operate with fewer workers. Madam Chairwoman, as you know, my district is huge. It's almost 40,000 square miles, and it comprises almost entirely of public land. We have 4 national parks and millions of acres of BLM and Forest Service land. Raising the cost of businesses to operate on these public lands will certainly have an impact on local jobs and the ability of guides and outfitters to provide the remarkable experience that attracts millions of visitors from around the world every year to our public lands. We have other witnesses here who I'm sure will elaborate on how some of these new costs will impact their businesses. But I'd like to briefly read from a letter sent to me by a tour operator located in my district that addresses his concerns. He says, I quote, "We very much want to maintain our commitment to the recreational experience in national parks and on public lands. However, the cost of compliance and the draconian overtime restrictions created by this rule have significant impacts on our business. So this is very serious to us, and we may have to cease running trips in national parks." This business owner is not alone. I'm sure the other witnesses today will testify of similar concerns. To address these problems, I have proposed the Outdoor Recreation Enhancement Act is to simply clarify and expand an existing exemption to wage and hour laws for seasonal recreational establishments under the Fair Labor Standards Act. The bill will broaden this exemption, which currently exempts ski resorts, to include businesses involving rafting, horseback riding, hiking, cycling, and other seasonal recreational business. And I think that's key to point out. These are seasonal recreational businesses. It's also important to emphasize that these businesses typically employ high school and college students who are looking for a position for summer and want to spend time outdoors. Congress already recognized how these circumstances applied to similar industries almost 40 years ago when it exempted the ski business operating on public lands. My bill is a simple fix that will allow these businesses to continue to operate on federal lands and allow all of us the opportunity to enjoy extraordinary experiences in our national parks and other public lands. And for those reasons, I'm grateful for this opportunity to appear before the subcommittee. And Madam Chairwoman, I yield back my time.
Thank you, Congressman Stewart, for being here today, and we so appreciate the work you're doing on the Appropriations Committee. Your bill, I believe, is an important bill to address the very situation that is the subject of this hearing. With that, you are excused, and we will just pause while the next panel of witnesses joins us. Thank you.
Thank you, Madam Chair.
Thank you, Representative.
Gentlemen, please join us. And before I recognize you, is it Lazary or Lazari? Lazari. Thank you so much. Okay. You ready? Okay. We will now recognize our second panel of witnesses. I'm pleased to welcome Mr. Michael Lazari, Assistant Administrator for Government Contracts at the U.S. Department of Labor, Mr. Mike Cottingham, owner of Wilderness Ventures, and Mr. David Brown, Executive Director of the America Outdoors Association. Welcome, gentlemen. Pursuant to committee rules, all witnesses will be sworn in before they testify. So please rise and raise your right hands. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Please be seated. Let the record reflect that all witnesses answered in the affirmative. In order to allow time for discussion, please limit your testimony to 5 minutes. Your entire statement, if it's longer, will be made part of the record. I now would like to recognize our panel. Mr. Lazari, you are recognized for 5 minutes. Welcome. Thank you for being here.
Good morning, Chairman Lummis, Ranking Member Lawrence, and members of the subcommittee, and I thank you for the invitation to testify today. I appreciate the opportunity to discuss the effect of the Executive Order 13658 on outfitters and guides operating on federal lands. On February 12th of 2014, President Obama signed the executive order requiring certain parties that contract with the federal government to pay covered workers no less than $10.10 hourly wage. The order obligated the department to issue regulations to implement its requirements. The department accordingly proposed regulations implementing the executive order on June 17th of 2014 and published final regulations later that year on October 7th. As Secretary Perez said upon issuance of the final rule, no one who works full-time in America should have to raise their family in poverty. And if you serve meals to our troops for a living, then you shouldn't have to go on food stamps to serve a meal to your family at home. By raising the minimum wage for workers on federal contracts, we're rewarding a hard day's work with fair pay. This action will also benefit taxpayers. Boosting wages lowers turnover and increases morale and will lead to higher productivity. The department conducted a robust outreach effort during the drafting of the rule, including conducting a variety of listening sessions with private associations and other groups. The department has continued to provide additional outreach since issuance of the final rule, producing a number of fact sheets, frequently asked questions, webinars, and other guidance to help contractors understand and implement the rule's requirements. The department has worked with contracting agencies to develop additional guidance concerning application of the executive order to particular agency agreements that apply to particular stakeholders. The order itself applies to 4 categories of contracts, including contracts in connection with federal lands and related to providing services for the general public, provided that such agreements qualify as new contracts. Our final rule defined a new contract as one that results from a solicitation issued on or after January 1st of this year, or that is awarded outside the solicitation process on or after January 1st of this year. So even if a contract satisfies these criteria, the order only covers individuals working on or in connection with the contract if those individuals' wages are governed by the Fair Labor Standards Act, the Service Contract Act, or the Fair Labor Standards Act. In their comments, the AOA and oars companies sought clarification as to whether or not the order applies to special use permits, commercial use authorizations, and outfitter and guide permits issued by the Departments of Interior and Agriculture. In its final rule, the department defined contracts and contract-like instruments as agreements between 2 or more parties, creating obligations that are enforceable or otherwise recognizable at law including but not limited to lease agreements, licenses, or permits. The permits addressed by AOA and ORS typically authorize the use of federal land in exchange for the payment of fees to the federal government, creating obligations that are enforceable or otherwise recognizable at law, and therefore would constitute contracts under the purposes of the executive order. The Department considered the information provided by the AOA and ORS and determined that even if their contracts with the federal government were outside the scope of the Service Contract Act, those contracts were covered contracts because they authorized the use of federal land and relate to offering services to the general public. In addition, wages of the workers on these contracts, even if not covered by the SCA, are likely covered by the Fair Labor Standards Act. Now, because the executive order applies only to new contracts, wage increases will not affect contractors that are midway through performance of the contract that was entered into before January 1st of this year. We have found that assertions that a contractor will be adversely affected by the EO often overlook not only the benefits of the EO, but also the fact that the EO only applies to new contracts with the federal government, enabling contractors to prepare for any potential economic impact of the EO. I'd like to thank you again for inviting me to testify in the payment of the 1010 minimum wage to outfitters and guides working on federal lands. We invite the AOA and others to provide us, as well as our counterparts at Agriculture and Interior, with additional information they believe may assist those agencies in the development of additional guidance. We will do our part to provide them with our views. We welcome and look forward to continuing the dialogue. Thank you.
Thank you, Mr. Lasseri. I would now like to recognize Mr. Cottingham for 5 minutes.
Thank you. How do I turn this on? Okay. Thank you, Madam Chairwoman and members of the subcommittee, for the opportunity to offer my support for H.R. 2215 and to explain why the Department of Labor Rule Executive Order 13658 threatens the viability of my program and numerous similar travel camp programs and summer camps for youth operating on public lands. In 1973, my wife and I quit our teaching jobs in order to create an alternative educational experience for young people. The purpose of our program has been to assist young men and women in becoming responsible adults through team building, group living, and caring for one another in challenging outdoor activities. Since 1973, we have provided life-altering experiences for over 24,000 young adults, including children of several governors, congressmen and women, and senators. Our self-funded scholarship program enables at least 30 deserving young people who couldn't afford it otherwise to participate in these experiences each summer. Our programs operate in 17 federally designated wilderness areas and 12 national parks throughout the United States. These adventures range from 2 to 5 weeks in length and usually involve our subcontracting activities such as rock climbing and whitewater rafting. Executive Order 13658 would require our monitoring compliance of over 30 subcontractors we work with operating on federal lands, which would be extremely difficult, if not impossible, for us from both a personnel and a financial perspective. If they fail to meet the requirements of the Department of Labor rule and do not pay their staff the higher minimum wage for federal contractors, then we would have to make up the difference. Each summer, we hire between 80 and 100 leaders who are current college students and graduate students. They work 6 weeks on average while they guide our groups on public lands. They also participate as clients with our students on a variety of subcontracted activities, such as climbing Washington's Mount Rainier or Wyoming's Grand Teton, or rafting for 4 days on Idaho's Salmon River or Utah's Colorado River. As is the case with hundreds of summer camps and other similar travel camp programs for youth, we must price our programs competitively. The implementation of the Department of Labor rule would not only be impossible to calculate, but would be impossible for anyone in the summer camp industry to afford, as it would increase our salaries dramatically. Implementation of Executive Order 13658 would shut down many summer programs for youth unless they were eligible for an exemption under the Fair Labor Standards Act, as it would be impossible to meet the payroll requirements of camp counselors who must be on call 24 hours a day for multi-week employment periods. As a seasonal educational summer program for teens, we also view ourselves as a training program for young leaders. Nearly all of our staff members view their time with us as a break from the rigors of school or as a final opportunity to share their love for the out-of-doors with youth before they pursue full-time careers in law, business, medicine, the arts, etc. Leading a group of young adults for several weeks is a challenging and very fulfilling opportunity, as it provides a platform for which stresses responsibility, accountability, organization, and many other life skills required for success. I always tell my staff that if you can successfully lead one of our programs, you are well prepared for future and larger challenges. I very much appreciate your attention to this issue and to the corrective action of H.R. 2215, which will be necessary to save many summer camps and travel camp programs similar to mine from going out of business. Thank you.
Thank you, Mr. Cottingham. And Mr. Brown, you are recognized for 5 minutes.
Thank you, Madam Chairwoman and Ranking Member Representative Lawrence. I so much appreciate the opportunity to offer America Outdoors support for H.R. 2215, and I'm also testifying to explain why the Department of Labor rule implementing Executive Order 13658 threatens viability of many outfitters and guide companies operating on public lands. The implementation of this rule may force many of them out of business. While the minimum wage increase is an issue for some seasonal businesses which hire a large number of entry-level employees, the larger issue is compliance with the complex Department of Labor clause included in this rule, which will become part of every new permit. Permit holders are required to comply with the DOL clause or face potential disqualification and loss of the permit. As you will see from my testimony, compliance is very difficult for family-run seasonal businesses who do not have a team of labor lawyers on their staff. The Fair Labor Standards Act includes an exemption for employees hired by seasonal recreational establishments and a partial exemption for recreational establishments under permit by a federal land managing agency. Inconsistent interpretation of the recreational establishment provision under 13A29 leaves many public land outfitters uncertain as to what overtime standard they are subject to. Some courts have ruled that recreational businesses do not qualify as an establishment under the FLSA if the recreation venue is more than 6 miles, or in one case, more than 9 miles from their headquarters. In these situations, some outfitters would qualify for the exemption, but others providing services in the same area might not. Outfitters with traveling camps may not qualify as a recreational establishment according to another court ruling. The DOL rule requires permit holders to enforce the contract clause, as my colleague mentioned, on their subcontractors and make up the difference between the executive order wage and the wage paid by the subcontractor. Some outfitters subcontract with other outfitters for services. Other subcontractors are not even operating on public lands. A guest ranch in Wyoming, for example, might be expected to require a laundry service to comply with the DOL rule and include the standard contract clause in their contract with the laundry service. Enforcing the DOL contract clause on a subcontractor will be impossible for seasonal recreational businesses. In analyzing the compliance quandary faced by many outfitters and guides, a law firm specializing in Fair Labor Standards Act compliance concluded, although most courts in the Department of Labor consider the same issues when determining whether a company is a seasonal recreational establishment, there's very little consensus regarding how to analyze these questions, much less the outcome of the review. If the courts, the Department of Labor, and various law firms cannot reach consensus on the interpretation of the FLSA in this area, how can a family-run business be expected to comply? Unfortunately, the quandary now puts their business at risk because it is part of permit compliance. The DOL rule also requires permit holders to enforce the contract clause on their subcontractors, as I mentioned, and that is one of the other challenges that with compliance, it will be very difficult. Aside from the uncertainty and difficulty with compliance, the FSLA correctly interpreted the need for an exemption for seasonal recreational businesses. That exemption needs to be fully restored for these businesses to survive in the long term, and that is why we support H.R. 2215. Looking beyond the issues related to Executive Order 13658, the accumulation of regulations and their costs on these small outfitter and guide businesses are making their ability to provide services to the public increasingly tenuous. I respectfully request that you continue your oversight and hope that members of the subcommittee will work together to encourage the executive branch to streamline and reduce the regulatory burdens which jeopardize employment and the high-quality recreation services the public currently enjoys on public lands. Thank you.
Thank you, panel. The members of the committee will now ask questions, and the chair will begin. She will recognize herself for 5 minutes. Mr. Lazzari, in response to comments on the executive order implementing rule, Department of Labor said that any increase in costs to business would be offset by gains in output or quality of service, perhaps even increasing revenue. What study or information was used by DOL to reach this conclusion?
Thank you for your question, Madam Chairman. In studying the issue, the department relied upon a number of empirical studies that focused on the impacts of productivity that increasing the minimum wage could have, or increased wages. I'm prepared and very happy to provide a very complete answer and a question for the record following, rather than citing individual studies, if that's okay.
We may follow up with you asking for copies of those empirical studies. In response to comments that raising the minimum wage of these seasonal employees would lead to staff reductions, Department of Labor said there were alternative ways for these businesses to operate without reducing staff. Mr. Lazzari, what are these alternatives?
That's a very good question, and thank you again. When we looked at the potential economic impacts, again, we studied increases in productivity that could result from an increase in the minimum wage, and the potential that an increase in the quality of the services that are provided could in turn lead to an increase in the number of customers that would bring additional revenue to a particular employer. In the department's final rule, we did consider this information generally.
Has DOL performed an analysis of the outfitting and guide industry to identify better ways they can operate?
Thank you again for the question. I believe that, you know, the department, when we considered the information that was presented to us, and as in any rule of general applicability, we look at the impacts of a particular rule pursuant to the Executive Order 12866.
So the answer is no? The answer is no, right?
We're happy to take additional information to
Well,
help.
wait a minute. The answer to the question.
The answer to the question is specific to that industry. We did not look at the particular impacts of the rule on any particular industry.
Thank you.
We looked
Mr.
at all.
Cottingham, the Department of Labor says this order is good for everyone because it will result in reduced absenteeism and turnover, improve employee morale, increase quality of services. Could you comment on that statement as it applies to your business?
Yes, ma'am. First of all, implementation of this would basically put me out of business. Our average salaries are about $2,500 a summer, and it would turn the industry, at least for teenagers and summer camps for children, into elitist opportunities only for people with a ton of money who could possibly afford. And I see that as a real problem.
So you don't believe it'll make your business more successful?
Oh, well, no, it could not make it more successful. I would not be able to have a clientele except for maybe 50 or 100 people who could probably afford to pay what I would have to charge.
So you would have to reduce staff or go,
totally reduce staff or go out of business in my particular case. Yeah.
Mr. Brown, can you talk about the important impact the members of your association have on the economies of local communities?
Well, in one recent economic study on the Ocoee River, the recreation activity on that river created 622 full-time job equivalents and 43 million in economic benefits within the 60-mile radius. This is a rural county, very poor, So many of the local residents sustain themselves in part by the jobs, seasonal jobs on that river.
Because they operate seasonally and the seasonal nature of these businesses makes it a different business model from the traditional model, should there be a different minimum wage requirement?
Well, I think that the basic federal minimum wage requirement is, obviously the one that should exist for these businesses. Seasonal, or, the exemption from the seasonal, there was, in 1939, the Fair Labor Standards Act anticipated an exemption for seasonal recreational businesses, which was appropriate, I think. And that's what we're trying to restore. It's an exemption that exists for organized camps, for ski areas, and for a number of other nonprofit conference centers and a number of other similar businesses.
Thank you. My time has expired. I now recognize the ranking member for 5 minutes.
Thank you, Madam Chair. And thank you, gentlemen, for your information here today. My first question goes to Mr. Lazara, correct?
Lazari.
Can you explain why the outfitter and guide business was no longer exempted from the FLSA, Fair Labor Standard Act, starting in 1977? It is my understanding that the exemption was removed, and today the discussion again centers around making those businesses exempt so that the federal minimum wage will no longer apply. Can you tell me the history? Why was it removed?
I'm happy to, Ranking Member Lawrence. Thank you for the question. We've looked again at the legislative history for the 1977 amendments and their specific mention of wilderness workers and why they were pulled out of the exemption, and it was based on just a simple premise that for work that's performed on federal land should be covered by federal laws and standards.
Can you tell me why the Department of Labor, why are the outfitter and guide businesses which hold permits required to be covered by the executive order?
I'd be happy to. Thank you. When we looked at the requirements of the executive order and the categories of covered contracts in the executive order, there were 4. There were contracts that were covered by the Davis-Bacon Act, by the Service Contract Act, concession contracts that had previously not been covered by the Service Contract Act, and then also a 4th category, which is the category which is relevant today. And it was agreements that were in connection with the use of federal lands for the general public. And when we looked in our notice of proposed rulemaking and also at the comments and considered the information that was provided to us, it seemed to be fairly clear that the executive order intended these particular agreements to be exempted. These particular agreements to be covered by the executive order.
Mr. Cunningham, can you explain to me, you mentioned your industry and the services you provide, which are very impressive. Why should the people who work on federal lands in the outfitter and guide industry make less money than other employees by federal contractors on those very same lands? Why?
First of all, in my particular situation, my employees are on duty 24 hours a day. So we're talking about a minimum wage plus overtime on a 96-hour week, if my calculations are correct. And that type of level of wage is simply not possible in the summer camp industry. It's just not possible to achieve. And did I answer that question to your?
Yes, I have a follow-up question.
Yes, go ahead.
In your timekeeping requirement for your employees, aren't there guides that when they're on several days, they have logs of sleep time and interruptions? So if a person is out on one of these, they're not on the clock for the whole 24 hours. Aren't there logs for sleep time and interruptions?
Yes, it's my understanding, Congresswoman, that you have to obviously get sleep when you can get sleep.
But it's not a 24-hour. If someone's out on a thing, they're not paid for every single hour that they're out. Okay.
No, they're paid on a salary basis for the.
Okay, I have another question. Mr. Brown, you stated something that is kind of what a point I wanted to make. You said that it's a rural area and there's poverty, and the jobs that we're talking about aren't only young college students. They're not only the people who are entry level. The type of jobs that we're talking about sometimes sustain in those rural areas employment and income on off seasons for people in your area. Is that correct?
I think if I understand your question, yeah, a lot of this income is supplemental.
Yes.
And
that's my point.
Yeah, and it's certainly for the students and the entry-level employees, it's helping them get through college or.
But it's also supplemental for those who live in that area.
And it's exactly.
For working adults.
Yeah, and most of those working adults are actually paid more than the minimum wage. So it's not an issue for the more experienced employees in the managerial positions. Usually if they've got families, they have enough experience that they're making more than the minimum wage.
But they hold these jobs we're talking about, correct?
Some of they hold.
They do hold these jobs we're talking about.
Some
working
higher level jobs,
adults.
yes. The entry-level jobs are usually held by students and young people.
But they have the same job classification.
Different duties.
But they are classified as outfitters, correct?
They're classified usually as guides or managers.
Yes. Thank you.
Yes.
I thank the gentlelady, and the chair now recognizes Mr. Meadows.
Thank you, Madam Chairman, and thank you for your leadership on this particular issue. It is of critical importance to me in that outdoor outfitters are a vital part of western North Carolina. Mr. Brown, you mentioned the Ocoee. There's the Ocoee, there's the Nantahala, there's the Chattooga. There's a number of different outfitters in my area. Sadly, in those counties, very close to many of those outfitters, the unemployment rate is at 15% still today. And yet, here we have, Mr. Lazzari, a rule that threatens to put many of those businesses out of business. And so the augmenting, it's great to say that we have a minimum wage at $10.10 an hour, but when you don't have a job, it doesn't really matter. So, Mr. Lazzari, I'm going to go to you because I'm troubled by some of the logic. You opened up with a quote with Mr. Perez that says no full-time worker should have to work, and yet we're not really talking about full-time workers here. We're talking about part-time and seasonal. So how would that apply to your opening quote from Mr. Perez?
Well, thank you.
Or would it?
Well, thank you, Congressman. When the department is considering the executive order and conducted its economic analysis, as I've stated before, we look very broadly at the impact of the executive order on all workers who would be impacted and all employers who would be impacted. And therefore, we don't look at the specific economic impact on one individual employer. We do recognize, however, in the executive order final rule through our economic analysis, that any impact for the increase in cost can be offset by the increase in benefits.
Now, how is that? You keep saying that. How many seasonal businesses have you actually owned, Mr. Lazzari? I've owned 4 of them, so you tell me how that's going to happen, because it sounds real good, but I am very troubled by you suggesting that it can be offset. Have you made payroll for seasonal businesses on a regular basis?
And again, I appreciate your question, Congressman. My role today—
Yes or no? Have you owned seasonal businesses?
I have not.
Okay, thank you. So let me go further. How can you make that kind of assumption? Hold on, let me clarify that, because that's too open-ended. Mr. Cottingham is sitting there right beside you. Mr. Cottingham, when we look at the business that you make, how much of your income do you get paid by the federal government to do? I mean, do they contract with you and pay you for these tours and guide services?
No, they do not.
So they're not actually contracting with you and paying you with federal dollars. What you're in fact doing is getting a special use permit to actually come on federal lands. Is that correct?
That is correct.
Because we can understand if you were getting federal tax dollars and we were paying you for that to set this new standard. Mr. Lazzari, do you not see the difference between the two of those?
Congressman, and I appreciate, again, the question. What I can say is that the executive order was very clear.
Do you see a difference? You're giving great answers to questions that I'm not asking. So do you see a difference between someone who pays for a service and then Mr. Cottingham who is getting a special use permit? Is there a difference? Yes or no?
Congressman, again, I appreciate the distinction that you're making. However, we did consider all of the information that was provided to us when we considered the final rule and in connection with our economic analysis.
So since you considered it, is there a difference? Yes or no?
That would be reflected in our economic.
So you saw no difference?
It was very clear to the department through the executive order.
All right, well, let me go. Since you're not going to answer that question, let me give you a different question. How are you implementing this particular rule with regards to people who have a special use permit here on the National Mall?
That's a great question, Congressman. We are continuing to provide additional outreach and guidance to all contractors, including businesses that are covered for special use permits, commercial use authorization.
So you have implemented it with regards to everybody who demonstrates here on the National Mall. Their contractors, subcontractors, and everybody else have to meet this new standard.
In May of this year, we recently conducted a webinar for all contractors where we answered questions live from contractors, regardless of their background, and interested stakeholders, and we'll continue to do so.
That's not the question I asked. I said, are you enforcing it? Yes or no?
The department is enforcing the executive order on covered contracts.
Here on the National Mall. Because I want you to submit that to the committee, and actually I'm here today because of some of the people that are in my district, because it's personal to me. It's going to put people out of business in western North Carolina. But I also have oversight over your particular agency and how it handles it. And so I would ask you give that to the committee on how you're doing it here on the National Mall, because under your definition, there is no difference from Mr. Cottingham and anybody else that gets a special use permit here on the National Mall.
We'd be happy to provide.
So are you implementing that?
Specifically to the National Mall, I would have to do additional research and be able to provide you a response.
All right. Madam Chair, you have been very generous with your time. I yield back.
I thank the gentleman. The chair now recognizes Mr. Palmer for 5 minutes.
Thank you. Mr. Lazzari, what is the meaning of verbal agreements covered by the rule?
I'm sorry, can you repeat the question, please, Congressman?
Okay. What is the meaning of a verbal agreement covered by the rule?
Verbal agreement, I'd have to be able to research that and get back to you. I don't know that we distinguish verbal agreements from any other type of agreement.
Well, following on Mr. Mehta's questions and how you have gone from giving permits to companies like Mr. Cottingham's organization to operate on federal lands, you've now decided that verbal agreement or that permit is now contract. And so you're going to impose this wage standard. Mr. Cottingham and Mr. Brown, you can respond to this as well if you'd like. The Department of Labor has contended that the outfitters have failed to consider that their sales might increase due to better service being offered by employees with higher morale. Are your employees suffering low morale?
I don't think any of my employees are suffering low morale. If you can climb Mount Rainier in the summer, kayak in Glacier Bay National Park, it is an amazing opportunity, and they love working with kids. They love sharing their love for the out of doors.
Mr. Brown?
Yes, I think this rule actually has the reverse effect. It does not increase the income of entry-level employees because these businesses are actually competing with other businesses outside public lands and have to set their prices accordingly. And so what a lot of outfitters are doing, having to reduce hours to stay on budget. And so the effect on morale certainly is not what the Department of Labor would anticipate from that standpoint.
Well, these businesses are different anyway from traditional businesses in that they are seasonal and they're subject to a different minimum wage requirement. Would that be an accurate statement?
Yes.
All right. The guides and outfitters typically operate by paying the federal government for a permit to provide certain services to the consumers on federal lands. How would you distinguish, and this is for you, Mr. Brown, how would you distinguish this permit arrangement from traditional contracts entered into between other entities?
Well, the permit is actually, it says in the permit that it's not a contract. There are different, I think if I'm answering your question, I understand it. There are Park Service contracts, and then there are certainly contracts that permit holders will have with other entities. The permit is, the Forest Service says the permit is not a contract, and the BLM will say the same thing. The only contracts specifically in our industry are Park Service concessions contracts.
Mr. Lazari, having heard his response, why is it the Department of Labor now classifies these as contract-like instruments?
Thank you for the question, Congressman. When we looked at developing the Notice of Proposed Rulemaking in the final rule, we referred back to the executive order definition, and the fourth category of covered contract is agreements for the use of federal land for the general public. And for us, when we looked at the information that was provided, and even during the comment period, and the information that was provided by the American Outdoors Association and Oars Company, another contractor or employer, we didn't see that there was, we at least saw that it was very clear that these types of agreements were contemplated as being covered by the executive order explicitly.
But you've never defined it like that before, until now.
Well, the executive order in the third and fourth category of contract covered a number of contracts that were previously not covered by the Service or by the Davis-Bacon Act, or arguably by the Service Contract Act.
Okay, I want to go back to a line of questions that Mr. Meadows was on, and he asked you if you had ever had a seasonal business. Have you ever worked for a business?
Have I worked for a business?
Have you ever owned a business?
I have not owned my own business.
Okay. I doubt that you'll be able to answer this, but I'll throw it out just in case. Is anyone involved in this process, making this determination? How many of those have ever owned a business?
I do not have that information.
My guess is, Mr. Lazari, that most of you've never, not only never owned a business, you probably haven't worked for a business, which I think explains a lot of how we come up with some of these policies that impact groups like Mr. Cottingham's and industries like Mr. Brown represents. And it's one of those areas that kind of defies common sense. It's rulemaking outside of an area of expertise that does not do any good. It doesn't increase morale, and it doesn't help create an environment where these businesses can make a living and thrive and offer opportunities for a lot of young people like Mr. Brown's talking about. It just makes no sense. Thank you, Madam Chairman.
I thank the gentleman. We'll now go to a second round of questions, and the chairman recognizes herself for 5 minutes. Mr. Lazari, would the rule apply to someone who gets a permit for filming on public lands?
For non-public lands?
Public lands.
For public?
If someone's filming on public lands, would the rule apply?
I would have to get back to you on that. For the particular instance, a lot depends on the contract and the particular services that are provided and the agreement.
It's a permit.
Again, and respectfully, Madam Chairman, I would have to consider that again. I don't want to provide an answer for you that's not complete or accurate. I'd rather be able to consider and provide you a more complete response.
I would ask for that. Please
Okay.
submit in writing whether it applies. What other permits would fall under the rule requirement?
So there are special use permits, commercial use authorizations, so permits, for example, in the Forest Service for use of other lands. There's those types of permits, permits issued by the Fish and Wildlife Service. There's a number of different permits or lease agreements. In addition, concessions contracts that were previously not covered under the Service Contract Act are now covered.
Does it apply to interns at the Wage and Hour Division?
That's an excellent question.
Would you let me know? Would you answer that question in writing as well?
I will go back and I will provide you a response. However, if the key to coverage for the executive order is not just that it's a covered contract under the executive order, but they would have to be covered under the Fair Labor Standards Act. So if they're an intern that's not covered by the Fair Labor Standards Act, they likely not be covered.
Mr. Cottingham, can you walk me through how this would apply to overnight stays? What kind of record keeping would be required if I were an employee of yours taking young people out on public lands for an overnight trip?
It would require another full-time employee, at least one in my office, at least one, to monitor all of this. And it would also require my leaders to keep logs in the backcountry, which is another hindrance to their primary charge, and that is the well-being and care of the young adults that they're working with. And I see that that would be very burdensome.
Mr. Brown, do you represent other businesses that do overnight trips?
We, mostly outfitters and guides.
Okay, so
We have guest ranches as well. And
so these people are out on horseback sometimes.
yes, hunting trips, a variety of outdoor recreation
Okay,
experiences.
so are they going to have to take notebooks with them to keep track of, to log all this? Like when they're asleep, when they're awake?
They would, and it's even more complex than that because they have to keep track of the meals they eat and then take the value of those meals, add those to the base wage when overtime's calculated. If they operate under a covered, if they're employed under a covered contract, activities under a covered contract, and activities are not on a covered contract, they have to keep records, precise records of the time spent on the activities under the covered contract and the activities that are not on the covered contract. For example, if you're not working on a permitted activity, you're doing something at a guest ranch, that's not related to the permitted activity, you're not covered by the rule. But in order to not have to pay or, you have to have very precise records.
And so the employee has to understand when they're working on a covered contract versus non?
That's correct. If they're keeping the log. And very often, as you know, when you're working 2 or 3 different types, multitasking at any business, small business, you're hopping from one task to the next. You might be packing lunches for a pack trip out in the back country one minute, and the next minute you might be tending to horses that are used just on the guest ranch.
I can't imagine the complications associated with this rule
It's
for
very
outfitters and
complex.
guys.
Yes, ma'am.
Last question. Mr. Lazzari, sort of on a different subject. I know the Wage and Hour Division is currently working on updating the special procedures that govern the H-2A visa program. Sheep and cattle grazers help the federal government manage much of its federal land. Many of my constituents utilize the program, the H-2A visa program. And for example, Mountain Plains Agricultural Service in Casper, Wyoming, works with them. Mountain Plains has repeatedly tried to meet with your division to discuss their concerns and provide input, but has been denied. I know you're dealing with a deadline imposed by a court case, but will you commit your organization to meet with them and other stakeholder groups?
I appreciate the question. My role, Madam Chairwoman, is to represent the Wage and Hour Division, particular to my specific branches in the government contracts arena. What I can do is I can take back the concerns that you have and be able to raise them with our leadership. I can commit to that.
Thank you. And I would ask you to identify a specific person that will respond in writing to my request. And thank you. Ms. Lawrence, you're recognized for 5 minutes.
I just want to say I have to go to another committee member, but my goal, my bucket list is whitewater rafting, so I may see you gentlemen soon.
If the gentlewoman will yield for just a second, you have a standing invitation to come to Western North Carolina at my expense.
Well, I get to determine what level of the whitewater rafting. That's the only thing. Gentlemen, today, I hear the concerns of the industry. Mr. Lazzara, can you please tell me if, with the executive order, is it immediate? Is there a phase-in? What would be the impact or the time frame on the impact that this executive order will have on this industry?
Well, the executive order, in the final rule, the department defined new contracts as covered. The new contracts entered into after January 1st of this year. So if a permit holder had an existing permit in December of last year and they had a 2-year permit, as I believe that the AOA has specified, or commonplace, then they would not be required to be in compliance with the executive order and pay the 1010 until 2 years, until the expiration of their contract.
I have a question. There is a lot of concern because the businesses are operating as you are now, but we're saying things like it's going to have, Mr. Brown, you stated, it's going to result in unemployment and reducing of pay. What is your data, and where do you get that data from? Is it a concern? Has it been documented? Where does that come from?
Excuse me. Thank you, Congresswoman. It's actually what my members who've had this contract clause on their permit have said. Some, as Mr. Lazzara said, new permits have the contract clause on them. We have some outfitters who've gotten new permits with the contract clause on it. In fact, they were told in December 1st that it was going to be on their permit, which was issued shortly after the first of the year. They were totally unprepared for it because they'd already sold trips. And so their response was that they had to adjust their employment, reduce employment, cut hours. They went from 8-hour days to 7-hour days, for example, in order to accommodate the increase for entry-level employees primarily.
Two things that I heard. I firmly believe that raising the minimum wage has a positive impact on all of America, and I'm very strong on that. But I do also understand that in doing business, that you need the opportunity to make those adjustments, and there is an immediate impact. Mr. Lazzara, you have stated that there has been some training. I would like, for the record, what are you doing to assist these companies in the transition? Some of the things that was stated by Mr. Coddington and Mr. Brown, in this industry, you're already doing, because you already have individuals who are performing these tasks, and you are keeping, because you have a federal contract now, and you do have to separate the activities. So I don't see that as being an additional burden. I see that as you doing business. The last question I have, how long, Mr. Coddington, have you been in the business?
Congresswoman Lawrence, I have been in the business for, this will be the 43rd year.
Wow. So I would consider you a pro. What I want stated for the record, during that time, the fee that you charge for individuals participating in your services, they've been increased over the years, correct?
Some years, yes, not all.
But over the, let's say the last 10 years, you've increased the fees, I'm sure.
Most certainly as cost of living has increased, yes.
Yes. And the point I want to make is the cost of living has increased and you had to make business decisions. People who work every day are confronted with that same issue. And fundamentally, that's why I am a very strong component of increasing the minimum wage. And as businesses must do what they need to do to meet their bottom line, because we need strong industry. Across the country, they're making those decisions to raise the cost of their services. I drive an automobile. It's never been the same price. But we also need to be focused on the cost. But I feel that we should support you in preparing you for that so you can make the right decisions. Thank you.
I thank the gentlelady, and the gentleman from North Carolina is recognized for 5 minutes.
Thank you, Madam Chair. Mr. Lazzari, since we were talking about outfitters, it would be appropriate for me to say that I have a burr in my saddle with regards to this particular rule that you have put forth. And so in saying that, can you assure the committee that you are fairly and equally, and with the emphasis on equally, applying this rule to all U.S. citizens who contract in one way or another under your definition with the federal government? Are all of them having to meet the same standards?
Thank you, Congressman. What I can say is that we do our best for all the laws we enforce to ensure that we enforce them consistently and fairly for all employers and on the behalf of all employees, regardless of background.
Okay, so you're doing your best. So how do you do that? Going back to the National Mall, other than your webinar training, how are you putting the same requirements on those permit holders as you would Mr. Brown's members or Mr. Cottingham? How are you doing that?
Thank you, Congressman. We work very closely with contracting agencies to make sure that they have the right training, so that way they're inserting the contract clauses appropriately.
But it's a different standard, Mr. Lazzari, and let's have an intellectual discussion here. There's a difference between enforcement and training. So how are you enforcing that with regards to that?
And I appreciate the question, Congressman. We treat those equally. We provide an equal amount of outreach and enforcement, not just for this particular executive order, but for all the laws we enforce, and we'll continue to do so, and have made the offer to the AOA.
All right, so you mentioned that you listened to all kinds of stakeholders while you were doing this rule. The majority of the stakeholders that responded, were they in favor of this rule?
In the comment period, Congressman, to answer your question, I appreciate it again, we received 6,500 comments, not all unique. We received about 100 unique comments opposed to the rule.
And so are you suggesting that there was 6,400 unique responses in favor of the rule?
No, but I can get you more specific information as far as the breakout of the number.
All right, so you're saying only 100 people complained in the comment period?
During the comment period, we received only 100 comments, or I don't want to say only. We received one because every one is valuable.
So how many of those recommendations did you implement?
Well,
because you keep coming back to talk about the executive order said this, the executive order said that. It sounds like you didn't really pay attention to any of the stakeholder input as much as you did what the executive order said.
Well, Congressman, we did make changes to the final rule to exempt new contracts from the coverage.
But in this particular case, there's a new contract. If I'm traveling on a federal road and paying a toll, I enter into a new contract each and every time that I do that because I'm paying a fee to use a federal asset. So is that a new contract?
Congressman, I would prefer not to respond to the particular circumstance without giving it more thought. But my understanding is that would probably not be covered by the executive order.
All right, so what about if I lease a building from the federal government? Do I have to comply with those standards when you're the lessor?
There are a number of requirements, Congressman, not just under the Executive Order, but the Service Contract Act that would govern contracts governed by lease agreements as well.
So I would have to meet the new executive order if I'm a leasee.
Well, Congressman, you would likely have to comply with not just the Executive Order, but also the Fair Labor Standards Act.
But that's a different number. And so when we really look at that, so let me go on a little bit further. Is there, in your opinion, any way that we can give a waiver to seasonal businesses and that you readdress this and work this without us doing a legislative fix? Are you willing to look at that?
Thank you, Congressman. We're happy to take additional information. However, we did consider these types of agreements in conjunction with the scope of the executive order, and we determined that these agreements were clearly ones that were meant to be covered by the very terms of the executive order.
So again, it was more what the executive order said than what the stakeholders said.
We considered both.
All right. So how many times did you go out and visit seasonal businesses before you made your rule? You personally, how many times did you go? Since you're one of the ones that are in charge, how many times did you travel to see the impact?
I can't comment on that. I actually don't have.
So did you go or not?
I can't tell you for sure.
So you don't know whether you went to a seasonal business or not?
I can look back and I can respond, but I can respond in questions for the record if you prefer.
So it wasn't that long ago. So did you travel to go and visit personally or not? Come on, Mr. Lazzari.
I do not want to provide you with an answer that's inaccurate, Congressman, but I do appreciate the question. I understand the importance of this issue to you, and I do want to provide you with a more complete response.
So you may have.
I can't say for sure.
Madam Chairman, I find it just amazing. I hope that his wife, or if you're married, that you can remember your anniversary better than you can potential trips.
The chair now recognizes the gentleman from Colorado for 5 minutes.
And I would be glad to yield to the gentleman from North Carolina. I'm enjoying this, so I don't have any questions, so if you'd like to continue.
I have one other question, Mr. Lazzari. If you say you're willing to take additional input, but yet it's not going to affect the outcome, why take the additional input?
Well, I can talk about the testimony provided by the American Outdoors Association as an example. Providing additional compliance assistance can resolve some of the issues that have been raised that we believe may not be exactly accurate. For example, for meals and breaks under the Fair Labor Standards Act, the AOA has referred to that as a burden. But that burden, as it's described, is currently required by the Fair Labor Standards Act, but only if you take a credit as an employer against the minimum wage. So you're already reducing the hourly pay for that hour where a meal break is being provided. That is why these employers are provided or are asked to keep logs. And for the department, we would be happy to provide additional compliance assistance because we think that there are ways, just based on the testimony, that we can help clarify some of the misperceptions that we believe the industry has about the rule.
All right. Madam Chairman, I want to close with one other request, Mr. Lazzari. Since you can't seem to recall whether you've been there or not, are you willing to accompany me to some of the seasonal businesses in western North Carolina so that you can see firsthand what you're talking about and the rules that you are and how they potentially impact people that are dealing with double-digit unemployment in western North Carolina? Are you willing to go with me? I'll be glad to pay.
I appreciate that, Congressman. I would have to consult with the department as far as what I can do. However, I'm more than happy to consult with also additional employers. In addition, members for the AOA, we're happy to respond to any questions that they have specifically to help them to be able to comply with the law.
All right. I thank you, Madam Chairman, for your leadership on this issue. I yield back to the gentleman from Colorado. I appreciate your graciousness.
Thank you. Mr. Cottingham, anything that you want to mention today that hasn't come up, anything that you think is important to put on the record?
Well, I've been in business for 43 years, and I don't know how many employees I've had over all those years. a lot. I've never met a mountain guide on Mount Rainier, Grand Teton, Mount Shasta. I've never met a river rafting guide on any of the rivers I've run who had low morale engaging in those kinds of activities. When I led for the first 9 years, I didn't just start a company and hire a bunch of people. I actually led. I led for 9 straight years with my wife. And those were the finest, most rewarding summers I ever had in my life. And when I hire a young person today as a leader, I am so thrilled that they have an opportunity to have the experience that I had. So I'd just like to add that, because I think the Department of Labor misses the whole point about this, the need for this exemption, because these jobs are for people who are not, in my particular case, I can tell you that they aren't people who are trying to put bread on the table and feed their families. They are people who are doing this because they just love the opportunity to share their enthusiasm. It's a pretty amazing group of people.
Thank you. Mr. Brown, same question.
Well, I think one of the concerns we have is a subcontractor requirement, that to require the Department of Labor contract clause to be put on any subcontract that a permittee has. We're still unclear on who qualifies as a subcontractor. We asked the Department of Labor to clarify that, and they refer us to the Service Contract Act. Well, there aren't many permittees who have the opportunity or inclination to read the Service Contract Act. So that would be one of the real concerns we have about implementation of the rule.
Thank you. I yield back.
Colorado, and we have been joined by Ms. Plaskett from the Virgin Islands. You are recognized for 5 minutes.
Going back and forth on this, and that Ranking Member Lawrence did ask some questions previously. I just had a couple of that I wanted to speak with Mr. Brown. I know that this was asked to Mr. Cottingham, but Mr. Brown, your testimony about the guides in the back country for several days have to keep logs of sleep time and any interruptions. The value of meals they eat has to be calculated and added to hourly computation for overtime wages. Is that correct, that keeping these records are not specified in the executive order?
No. Well, there's a requirement, Congresswoman, to maintain records for examination. Mm-hmm. And so I would presume that those records are required, although they're not referred to in the rule.
But it would be something that you would expect to be kept?
Yes.
Mm-hmm. And how would that change the amount of wages that individuals are receiving if you were to calculate that as well?
Well, potentially, if you certainly took a credit for sleep time, it would reduce the amount of pay.
Right, because you're sleeping probably almost as much as you're working, right?
No, probably not. Probably working more than sleeping.
Okay, well, that's how I work, but I don't know how other people. But it would significantly make the amount of pay that individuals are receiving per hour of a significant change.
It would change the gross pay, yes.
And when we talk about the gross pay, Mr. Cottingham, in earlier testimony, there was discussion about average salaries for the summer. 300 to 500 a summer? How many months is that?
Excuse me, I don't quite understand. 300 to 500, what are you referring to? Our average salary is approximately $2,500 for a 6 to 7 week employment period.
Okay, okay. So the employment period is how long?
6 to 7 weeks.
Okay, so for 6 or 7 weeks, they're making how much in gross pay?
$2,500, plus they are getting the bonuses of being able to climb major peaks, raft rivers, And
So the 3 to 500 amount, what is that, per week then? Is that what that is?
I didn't say anything about 3 to 500.
Okay.
Yeah.
All right, thank you for that clarification. Mr. Brown, can you describe any other specific burdens that the executive order will generate for businesses?
Well, the one issue that I described a little earlier was the requirement, for example, if you have an employee that works under a covered, part-time under covered contracts, and then part-time under activities that are not covered under the Department of Labor rule, then assuming that they are not paid the same scale for those other activities outside the covered contract, precise records have to be maintained so that you are able to show the Department of Labor how many hours are worked under the activities covered by the contract.
But that would just be good business practice anyway, would it not?
It would not be required without this Department of Labor rule.
Okay. And Mr. Lazari, is that correct way?
Yes, it is.
Okay. I'm very particular about the pronunciation of my name, so I try to get people's correct. How do you respond to business concerned about the increased labor cost affecting profitability? And then how has the department responded to that if there are those business concerns?
Thank you for the question. As described in the executive order, we did a careful economic analysis, and it was our determination based on that analysis that any additional costs that would be borne by employers could be offset by additional productivity increases, reduced turnover, less absenteeism, lower supervisory costs, for example. And the department continues to provide additional outreach and guidance and are willing to do so for the AOA and its members, to Mr. Cottingham and to others who have additional questions about how to comply with the law and how to comply in an easier manner, so to speak.
Okay, thank you. Thank you very much for the time.
I thank the gentlelady. The chair now recognizes Mr. Palmer for 5 minutes.
I want to go back to that previous question. Thank you, Madam Chairman. What you were saying that it would increase productivity and efficiency, but earlier in the rule it says increased costs can be offset in contract negotiations entered into by the businesses and its suppliers and consumers. This would imply that those people who did your little analysis might have anticipated that there'd be a cost increase. And you said this would, it also said this would either mean the payments it makes to the Forest Service and other land management agencies or to customers who are Americans using taxpayer-owned lands. Will the Department of Labor ensure that other federal land management entities, such as the Forest Service, for instance, will charge guides and outfitters less for public land permits to make up for the increased labor cost caused by the executive order? Any plans for that?
We've been working with other federal partners like the United States Forest Service to be able to answer questions from the regulated community and from their specific stakeholders. And we recognize in the rule that, you know, it is a rule of general applicability, and that we do not have all of the experience that some of the contracting agencies, like Bureau of Land Management, for example, would have with individual stakeholders, and we're happy to work with them to be able to help them answer additional questions. As far as influence over the cost of the permit, I would have to defer to the contracting agency.
Before you before you put forth this rule, did you sit down with anyone from the Forest Service, the Bureau of Land Management, any of these other agencies that deal directly with these businesses to discuss with them how this might impact these businesses?
Following the issuance of the executive order and then the development of the notice of proposed rulemaking and the final rule, and throughout our rulemaking, we do consult with with other contracting agencies and receive comments through interagency comments that we receive, and we respond to those accordingly.
So are you saying that you did sit down with the Forest Service and discuss how this would impact these businesses?
Congressman, we did receive their input.
And would you be willing to share that with the committee?
I would have to discuss that with the department, and however, if you request any additional information, we'll respond accordingly.
Madam Chairman, I would like to request that any documented discussions that they had with the Forest Service be provided to the committee. Mr. Brown, about a year ago, on behalf of the American Outdoor Association, you wrote a letter to Director Ziegler, I think it was in July of last year, and asking what is the meaning of verbal agreements covered by the rule. Did you get a response?
No, I did not. There were references in the final rule, which was 300 pages, but I would not be able to tell you the answer. Not sure there is one.
Mr. Lazari and Madam Chairman, I would like for Director Ziegler to provide a response to Mr. Brown's letter to Mr. Brown and to the committee, if I may ask for that.
Without objection, so ordered.
Thank you. The Forest Service doesn't view permits as contracts or contract-like instruments. Can you give me some explanation as to why the Department of Labor has decided to equate permits to contracts?
I appreciate the question, Congressman. When we considered the executive order, and we looked at the definitions, the 4 categories of covered contracts that were explicitly mentioned in the executive order, and when we considered the information provided by stakeholders, including the American Outdoors Association and others, Forest Service and others, it was clear to us when we looked at the executive order definition that the executive order very explicitly intended to cover just these particular types of agreements.
All right.
Under the fourth category of covered contract.
Madam Chairman, I yield the balance of my time. Thank you.
I thank the gentleman, and I thank all members of the committee and the panel. Thank the staff. Particularly want to thank our witnesses today. We appreciate your being here, appreciate your testimony. Mr. Lazari, you've been asked to follow up in writing on several matters today at the hearing, and we will look forward to your responses and the department's responses to our requests. Thank you all for being here. If there's no further business, without objection, the subcommittee stands adjourned.